Okay, so today we are going to discuss a very important topic which is in news from the last 1 month and has been in news from the last 5 to 7 years more often. A very important topic for Clat 2022 and Clat 2023, that is sedition law. So let's start with the topic and let me know if you have any doubt in between by writing it in the chat box. So let's first recognize these people. I hope you must be knowing this all people. Let me know the first person from the beginning, the person in white uniform. Let me know in the chat box. Be quick, guys. Let me know who is the person, the first person. Okay, getting the response. Yeah, Bal Gangadhar Tilak. The next person with the long hairs. Bal Gangadhar Tilak is the correct answer. The person with the Sadi Dimam, no. Sadi Dimam, no, no. Santosh. The person with the long hair. Anyone? It is Ashim Trivedi. Okay, then the person with the two couple. Who are they? The two couple sitting in the white dress with the Rana couple. Very good, Santosh. What about others? Yeah, Maharashtra case. Very good. And the last person, the famous one. Yeah, everyone knows. Kanhaiya Kumar. Okay, so you must have understood by now that why I have given the such faces in the first slide only, because all of this personality, whether it is famous personality or not, they had become famous after the sedition charges were imposed, and the latest case is of the two Rana couple, that is of the Maharashtra, because of the Hanuman Chalisa rule. So now let's move to the first slide and understand that what all have happened in the last some few days back and why it is important for you to understand the sedition topic. Now, let's start from the 2021. In 2021, a bench of Chief Justice of India, in a petition which was challenged by various persons, including Mahua Moitra of the TMC and various journalists, a batch of petition was filed challenging the constitutional validity of the sedition law. So, Section 124A, the very common section which is in use every time now. Now, this law was challenged in the Supreme Court in 2021, challenging the constitutional validity, and the petition asks the court to re-examine the KEDAR Singh case that we will be discussing at the last. So in 2021, Chief Justice of India, when the petition were filed, he made just a general remark that why such a colonial law which was used against our such a personality like Mahatma Gandhi and Bal Gangadhar Tilak, why such a colonial law which was used by the British to oppress the people of India, why such law is still in the India when we are celebrating Azadi Ka Amrit Mahotsav. Okay, now after 1 year, there were various time when the case was heard, and the central government. So who represent the case in the Supreme Court? Does the central government, does the law minister himself represent the case? No, the final case that we'll be discussing, the final case is only important, Roshan, not this petition. Okay, the final case in which the decision is being given, the recent decision, that is only important. So let me know, guys, who fights the case in the Supreme Court. Does the law minister himself fight the case, or whether there is some other person who files the case? Attorney General and the Solicitor General. Very good. So after all this, the Supreme Court was hearing the petition, and then after in the duration of the 1 year, the center, that is Attorney General, Solicitor General, in the first instance they stated that the sedition law is correct. There is no need to review the law. There is no need to struck down the law, and they take the use of the KEDAR Singh case that we will be discussing afterwards. But finally, after some time, when the government saw that the matter is not in their hand, they informed the court that they will be giving their written submission in the petition that was challenging the constitutional validity of Section 124. Okay, so previous slide, Ganesh. So the government has sought time and time after in the last 1 year, various time was asked by the Attorney General or the Solicitor General for the sedition, and they told that they will be giving the written reply. Next slide. So these are two articles from the Hindu, that can the sedition accused be get protection, because this is from the recent petition. And there is another slide image that you can see that panel wanted changes to sedition law. Now, when the in the recent case, just 5 days before, the Supreme Court asks that while that by the time you are reviewing the yeah, the sedition law, by that time those person who are accused of the sedition law, can they be granted any kind of protection? Can we stop registering the FIR or whatever we want? On the same thing also, the central government had sought time, and finally the Supreme Court had told that we will be keeping the sedition law in abeyance by the time you decide the law. Now, the panel that was formed by the Home Ministry, this is important, that is the Committee for Reforms in Criminal Law. The name of the committee is very important. If the question comes in your current affairs section, most probably it will be coming basically for Clat 2022 aspirant, it will be a the legal section question. But if you are getting in the current affairs section, so the name of the committee is very important, that is the Committee for Reforms in Criminal Law, which was appointed in 2020. So as we all know, the Criminal Procedure Code, the Indian Penal Code, this all are being again they are being reviewed by the central government. For that, the committee has been formed. Now this committee, what was the stance of this committee? That is the Committee for the Reforms in Criminal Law. The committee did not want to completely remove the sedition law. They want that the panel concluded that the sedition law can be amended and included in the category of crime against the state to protect the sovereignty, integrity of the security. Even the committee which was formed by the Home Ministry, they do not want the sedition law to go completely to get it struck down. They want to make new amendment in it so that the freedom of speech can be upheld in any case. So these are two important images. Next slide. So Supreme Court, as I just informed, that when the central government say that we will be the Solicitor General, the name of Solicitor General is very important. Tushar Mehta told that we will be reviewing the law. We will be re-examining that whether sedition law should be there or not. By that time, what we will be doing, that any case that is registered against any person in the sedition charges, that particular case will be done according to the Vinod Dua case. What was the Vinod Dua case? You must remember the famous Vinod Dua journalist case, in which, according to the Supreme Court, as per the Vinod Dua case, that it is the superintendent of police who will examine the FIR. Okay, the superintendent of police will examine the FIR which is filed for against any person for sedition, and then he will be giving reason for the same in writing. So these words are very important while you are reading the legal passages. Every time in the group or personally, aspirant asks us that how to read or comprehend legal passage. These are very important point, that the superintendent of police will give the reason in writing. Tomorrow in the any of the mock or in the D-Day on the Clat, which is very soon, only you are having around 30 days. So you are getting a question on the same thing, on the same topic, and you are getting a factual based question. You are missing the part. You are missing the part of the giving reason in writing. That is a very important term. So the moment you will be missing that particular term, giving reason in writing, the whole question of yours will get wrong. So it is very important while reading the legal passages to read it very carefully. We examine the passage very carefully. So the Solicitor General told that we will not stop the registration of FIR, we will not keep the law in abeyance. Instead, we will be following the Vinod Dua case. Okay, just make sure while you are making your notes, mark the date of the Vinod Dua case, the year in which Vinod Dua judgment was passed. So we will be keeping it according to the Vinod Dua case, in which the superintendent of police will be examining the FIR that will be registered against any person for the sedition, and he will be giving the reason in writing that why the sedition is important, why the FIR is important. This was the argument of the central government, that is by the Solicitor General, that is Tushar Mehta. The name of Solicitor General, Attorney General is very important. Now the bench comes here. This is also very important thing, the bench. So you can get the question in current affairs section also. The bench of our Chief Justice N.V. Ramana. Okay, you have the bench of N.V. Ramana. Then you have the bench of Suryakant and Hima Kohli. This was the 3-judge bench. Okay, a 3-judge constitution bench directed the central government and the state government that by the time the central government and the state government is re-examining the law, that whether sedition law should be there or whether it should be struck down, removed from the IPC, all the section of the 124A will be kept in abeyance. That means in a temporary stop. It will be temporarily stopped till it is being re-examined. So they told that there will be no, if the registration of FIR is taking place, then the registration of the FIR should be after very very crucial examination, and it will be open to the person against whom an FIR has been registered. That if it will be open to the person against whom the FIR has been registered, they will directly move to the court, and the court will accordingly grant the relief according to the judgment that was passed recently. So this two argument is very important. First, the Solicitor General, the name of the Solicitor General Tushar Mehta is representing from the central government and telling that we should not stop the law, we should not keep the law in abeyance. Instead, we will be following the Vinod Dua case. However, the NV Ramana bench, that is the three judge bench, is very important. The name of the bench, that is NV Ramana, Suryakant and Hima Kohli, they directed that no, you should not go for registering FIR until you are reviewing section 124A. So keep the law in abeyance, and if any fresh case is registered under section 124A, the party will move to the court, and it will be the duty of the court to grant the relief according to the judgment that we are passing today. That is the day on which the court, on which the bench passed the judgment. So no coercive stay, even against whom the sedition charge has been filed, against whom the FIR has been filed, even against them no coercive step will be taken by the central government or state government until and unless the government examine the law. I hope it is clear to everyone, guys. Let me know in the chat box. It is clear to everyone the arguments and counter arguments and the final what the Chief Justice stated. Okay, cool. Now let's move to the next slide. So Supreme Court puts the colonial sedition law on hold. These are very important points. As you can say in the first slide also, we discussed the famous case of Kanhaiya Kumar, against whom the sedition charge was there. Then you have Sarjil Imam, then various Kashmiri students, even then Tisa Ravi case, you remember. So Supreme Court suspended the criminal trials and court proceeding under section 124A, and all the pending trials, appeals and proceeding with respect to section 124A was directed to be kept in abeyance. On which the law minister, who is the law minister, guys? What is the name of law minister of India? So the law minister on this remarked that there should be a Lakshman Rekha and such thing. That is very general, that there should be a Lakshman Rekha. Yeah, very good, Santosh. Yeah, good. So there should be a Lakshman Rekha. The judiciary should not interfere. That is very common thing. So don't go for that. This is the Supreme Court has, as of now, the current status is that Supreme Court has put the sedition law section 124A on in abeyance. Next slide. So this was all we discussed, that what has happened recently, that the Supreme Court has put it on abeyance, the argument that was put by the central government. Now we have to understand the sedition law. It is very important for both current affairs and legal section for both Clat 2022 and 2023. How the sedition law started, what is the sedition law, and that all we will be discussing. I will be taking the questions at last, okay? Now let's start with the historical background. If we see the sedition law, so the sedition law was started in the England in the 17th century, when at that time the government of any country, basically the crown and those government, they feel that anyone who is not having good opinion about the government, they should not be allowed to do any government job, or they should not be allowed to stay free. Okay, because at that time everything was, whatever was that, it was the government. Okay, so that was, it was used. Now the Indian Penal Code, which was drafted in 1860, okay, you may have to remember that the Indian Penal Code was drafted in 1860. Can anyone know who drafted the Indian Penal Code? Let me know in the chat box. Who drafted the Indian Penal Code? So when the Indian Penal Code was drafted in 1860, very good, Abhiraj. When the Indian Penal Code was drafted in 1860, the law, we did not have the sedition law, that is section 124A. Okay, in the section 124A was not present there. By an amendment in 1870 by Sir James Stephen. These are very important, guys. Make sure I hope that you are making the notes from the same, from the slides. In 1870, by an amendment by Sir James Stephen, section 124A was introduced in the Indian Penal Code. So an amendment was brought, and section 124A, that is the sedition law, was introduced by Sir James Stephen. And so today in the Indian Penal Code 1860, which has been drafted, as you have very rightly pointed out, which has been drafted by Lord Macaulay, we have section 124. But in the original section Indian Penal Code, it was not there. It was introduced by an amendment of 1870. Okay, this is the historical background of the case. Next slide. Yeah. Now let's understand what does the sedition law state. So you will be, if you are getting any passage on the sedition law, either in your legal passage, you will be getting the same passage that is you are seeing on the slide. You will be getting the same sentences. Okay. What does the sedition law states? The sedition law is a very vast law. It covers a vast law aspects. It is not limited to anything. The freedom of speech and hate speech or any speech that is against the government, it is always there is a clash between the two, as you must have been reading various judgment, and the same issue is as of now also. So let's first understand the definition, which is very important for answering the legal question. Sedition states that, so it defines sedition as an offense committed when any person by words, either spoken or written, or by signs or by visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempt to excite disaffection toward the government established by law in India. Tomorrow, Aviraj is went to the one of the Choraha of his hometown and said that Khalistan Jindabad, Bharat Tere Tukre Honge. Okay, Khalistan Jindabad और भारत तेरे टुकड़े होंगे, और I will cut the chicken neck from, I will cut the chicken neck from Assam, or I will cut the chicken neck from the northeast. I will cut the northeast from the whole of India. So Aviraj went to the any of the Choraha, okay, and state this sentences. Does this amount to sedition, guys? Anyone? If you know sedition law from before, if you know, does this amount to sedition? Aviraj Utsav, if anyone went tomorrow to any of the Choraha and shout that Khalistan Jindabad or Bharat Tere Tukre Honge, or I will cut the chicken neck, I will cut the northeast from the. Okay, I got all the responses in yes. Still I'm getting response. Only one response I have got that is correct. No, guys. So yes, now I'm getting Ankit and Santosh. This is not sedition. That is what the Supreme Court has told in all the cases of Kedarnath Singh case, Kanhaiya Kumar case, then you are having Vinod Dua case, Disha Ravi case. In all this case, the Supreme Court has told this is not sedition. Until and unless there is a violence by your words. So Aviraj, yeah, now you are going right, guys. So Aviraj goes tomorrow and state that Bharat Tere Tukre Honge. This government, इस गवर्नमेंट को गिराते हैं, ठीक है, जितना जिस तरह से गिराना है गिराइए, ठीक है, आग लगा दीजिए पूरे देश में, वट एवर यू वॉन्ट टू डू, बट गेट दिस गवर्नमेंट रिमूव्ड. And the people of all the people of the hometown of Aviraj takes the all the aag or pura matlab banduk and everything they used, and there is a lot of violence around the whole hometown of Aviraj. That time it amounts to sedition. The moment till Aviraj was standing at the Choraha and shouting Bharat Tere Tukre Honge, or I will cut the chicken neck from the Assam, or I will cut the northeast from the whole of India, that is not sedition. The moment it results into violence, it is affecting the government, it is sedition. That is the same that we have seen in Kanhaiya Kumar case, what you have seen in the JNU campus. So it would, if that would have been sedition, what you guys are telling, then he would have been upheld by the sedition charges. But that is not so. So it is that, yes, very good, Santosh. That is the judgment of Kedarnath Singh case, that your words, whether it is by written, your spoken word, your signs, visible representation, whatever it is, that is not the issue. Your words should be such that it incites a disaffection toward the government by violence. So whatever you are speaking, it creates a violence. Okay, it creates a violence. Now let's point. Disaffection includes disloyalty and all feeling of enmity. However, comments without exciting or attempt to excite hatred or contempt or disaffection will not constitute an offense under this section, guys. Legal passage is not so easy, but if you get a control over the legal passage, you are getting very good score in the legal. This is why legal makes a difference. You can understand from here. Now let's talk about the punishment. So if tomorrow Aviraj is charged with sedition, he will be having a life imprisonment he will be having life imprisonment punishment from the 3 years to life imprisonment. He will be barred from any government job. His passport will be seized, and he have to present himself anytime whenever the court. Okay, that is the most. So it is considered the most draconian law, because the government job, you will not be getting any government job. You will not be getting any. You will not be getting your passport will be seized. You cannot travel abroad India, and such thing was there. But the major punishment is 3 years to life imprisonment. So if you're getting any question, you can do so. So this is the present sedition law that we are following, but as of Supreme Court judgment, recent Supreme Court judgment, it is put in abeyance. So no coercive step will be taken. Next slide. Ganesh, next slide. स्लाइड चेंज कीजिए. हाँ, चेंज नहीं हुआ है, वही वाला स्लाइड में सेडिशन वाला में. हाँ, हो गया, ठीक. Okay. Now let's understand that why the sedition law is important according to the government. Now, as we know, Article 19, Clause 1A, it is the freedom of speech and expression. Under Article 19, we have the all the six freedom that is given to the citizen of India. However, Article 19 Clause 2 states that there should be a reasonable restriction. So, if you should not tell something which is against the public morality, you should not cause enmity among different religion. You should not speak something which goes against the integrity of the country, against the sovereignty of our country, or against our friendly relation with other country. So, if tomorrow Ambika or Roshan goes and states something which goes against our relation with America, we know India and America is such a good friend. But because of the word of Vaishali or Roshan, the words that were spoken by them, there is a problem or enmity created between the relation of India and USA. That is the reasonable restriction which will be imposed on you. So Article 19 Clause 2 talks about the reasonable restriction, and the central government states that this sedition law is in continuation of the same. So you can tell anything. Very good, you are telling Bharat Tere Tukre Honge and you are then inciting violence. This is not acceptable according to the central government. Okay, then it is very important to maintain the unity and integrity of India. Now tomorrow you are going and speaking that I will cut the whole north of east from India, and the people of northeast start to violence. Okay, they come out of their house and they start killing other people of North India or South India, and there is the government has been destroyed, the parliament has been destroyed, the Red Fort has been destroyed. That is sedition. So to maintain the unity and integrity of our country, the sedition law was important according to central government, and it helps to protect the elected government from attempt to overthrow the government. Okay, by the illegal or violence means. So if you can know the how it happens in some of the our neighboring country, that by the violence the elected government is removed, and either other political party or even sometimes the army take control. You know whom I am representing the country. So either the government, other opposition party take the government, or most probably the military. Okay, there will be the military who will be having a control over the whole country. So to maintain the elected government, to maintain the integrity of our country, and to have a reasonable restriction on the freedom of speech and expression granted under our Indian constitution, the sedition law was important. Okay, according to the central government. Next slide, we will be understanding that what are the issues that we are facing in the. Yes. Now, this is a colonial law. Every colonial law which was used by the British government against the Indians has been repealed. Most of them, 95% of the colonial law has been repealed. However, this is such a law which was used against Mahatma Gandhi, Bal Gangadhar Tilak, Bhagat Singh. Okay, because of their writing, because of their activity, they were charged under sedition. So the Supreme Court asks, and the other opposition experts are asking, that such a law which was used by the British to oppress the voices of our freedom fighter, to oppress Indian voices, why such law is being used by the government? There is no need for such a colonial law. Okay, even the Constituent Assembly point has been mentioned, that the Constituent Assembly did not wanted the law to be included in the IPC because it will be curtailing the freedom of speech and expression. And definitely we are a democratic country, which is a very common so-called argument that is always put forward, that we are a democratic country, we should have freedom of speech and expression, so we should not use the sedition law. And one of the very important issue, another issue that is not mentioned, but the number of cases that is registered in the sedition is very high, but the conviction is very low. So if you see the data of the government or the NCRB events, so the number of cases that has been registered in the last 5 years has increased a lot, the number of sedition cases, but the conviction, okay, I hope you understand what is conviction. When the judgment is pronounced, the conviction in those cases is very less. Okay, out of, if there are 500 cases, then only 20 to 30 are the actual cases in which the conviction is given by the High Court, Supreme Court, or any court. So this is one of the important issues, that the number of cases being registered by the government is very high. Any government, whether it is the present government, previous government, or the state government, they are using or misusing the sedition law. Okay, yes, very good, Roshan. But out of the 500 cases, only 20 to 30 cases are there which are being convicted. So this is one of the very valid point that has been put forward in the all the court and even by the experts. Okay, next slide. Now we come to the famous case of Kedarnath Singh versus State of Bihar. This is a very important case. Whenever you get a legal facts, you guess generally that in Kedarnath Singh versus State of Bihar or State of Rajasthan, whichever is the case, that this was held by the Supreme Court. Accordingly, you have to answer the passage. So you have to read the case, very important. You should know what is Kedarnath Singh case. Because if Supreme Court struck down the sedition, even matlab tomorrow, if the Solicitor General comes and tell the Supreme Court that we are not going to repeal the law, we will be keeping the sedition law, we will be making amendment, but we are not going to repeal the law. If Supreme Court tomorrow in 2023, 2024, whenever it is, when Supreme Court is striking down the sedition law, it will be overcoming the Kedarnath Singh versus State of Bihar. Okay, so this was a landmark decision on the sedition, in which the constitutional validity of section 124A was upheld, guys. So remember, it was upheld. The constitutional validity of sedition was upheld by the bench. So there was a Kedarnath Singh who made a lot of slogans and who remarked against the CID and the Indian National Congress, and he told that all the Congress and the Jamindar, they were doing nothing, but they were using the government resources, the people and their land for their profit. They were not working anything for the government. They were just trying to bring more poverty in the country. As a result of which a case was filed under section 124A against Kedarnath Singh. This was the facts of the case. Next slide. So you don't have to remember the case, just as a law student you should know. But in 1962, the Supreme Court upheld the Kedarnath Singh judgment and tell that this is a correct law, but there should be some limitation on the use. So as you can see the third line, that is, the court held that unless accompanied by an incitement or call for violence, criticism of the government cannot be labeled as sedition. So tomorrow you go and shouts in front of your panchayat office or in front of your MLA office that the petrol prices are so high. Okay, the LPG cylinder prices are so high. The government should resign. All the people should use violence and get the government destroyed. The government should be removed. That will be amounting to sedition when you call for violence and there is a violence. Okay, but you go and shout that अरे petrol का दाम बहुत बढ़ गया है देश में, या LPG सिलेंडर का दाम बहुत बढ़ गया है, that is not sedition. You can be charged for sedition. You will be in the jail for 5 years, but that is not sedition in real sense. So in the Kedarnath Singh case, Supreme Court upheld the constitutional validity of section 124A and granted the and gave various guidelines that when it will be sedition. Supreme Court says that first of all we have to understand what is the government. The government established by law is here the state government, that is whichever state, for example it is the central government, then it is as at present the NDA government. At the state you are having the different government, whichever it is, whether it is Congress, TMC or BJP. It should be a government which has been established by law. That is very important, the Supreme Court says. So it should be according to the election. There should be Lok Sabha, Rajya Sabha election or whatever it is, assembly election, and thus the government has to be established. Now this sedition, that the act or the voice or the speech, whatever the person is giving, it should be such that it should create a hatred or enmity against the government among the normal public, and that hatred or that enmity should result in violence. So there should be the actual violence or there should be an incitement to violence. The public order should be destroyed, and either there should be an actual violence or there should be an incitement to violence. Then only the sedition can be imposed on any person, according to KEDAR Singh case. Next slide. So comments, however strongly worded, expressing disapprobation of action of the government without exciting those feelings which generate the inclination to cause public disorder by act of violence would not be penal. So time and again the same thing has been stated by the court, that it should be violence, there should be violence. The mere criticism of the government for anything is not sedition. There should be a violence, there should be a public disorder, that has to be the public order has to result into public disorder by means of violence. That only the Supreme Court has resulted in the KEDAR Singh case. Next slide. Okay, it is only when the words written or spoken which have the pernicious tendency or intention of creating public disorder or disturbance of law and order that the law steps in to prevent such activity. So the maintenance of the public disorder, in that cases only the sedition law should be used. It should not be used very frequently as it is being used now. So you see the recent case of Hanuman Chalisa row, that the two Rana couple they wanted to sit in front of the CM office and they were imposed with the sedition charges. Okay, now whether it is true, right or wrong, that not we are not here to judge. There is the court is there, they will be giving the decision, but I will just give you an example, or you take the example of Sarjil Imam or Kanhaiya Kumar. Next slide. Now, so this 3 point you have to remember for solving the question, guys. Now we are summing up the session. Just 3 point that you have remember when you are solving the question. There should be disaffection towards the government, that is established by law. Okay, the government should be established by lawful means. Now if you are just criticizing the government, that would not amount to sedition. If your speech, whatever you are writing, whatever you are speaking, whatever you are representing, your action, if it result in hatred with violence or an incitement to violence, then only it will be sedition. But such comments which express disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt or disaffection, that will not result in sedition. While you will be solving the question, that this will be helping you more. So we will be trying to provide you some questions on sedition very soon, or if we get from any other sources, we will be giving you, because when you will be solving the question, then it will be more easier to you for apply this theory, because this is just theory. You have to imply this on your question. Okay, next slide. Now, after the KEDAR Singh case, the public order has become a very important key term. Okay, the violence, the public disorder has become a very key term for charging any person with the sedition charges. And after the sedition, after the KEDAR Singh case, we have the Balwant Singh versus State of Punjab, in which the Khalistan Jindabad, Raj Karega Khalsa, and such thing were pronounced. But the Supreme Court said that this is not sedition unless and until it is resulting to violence. Then we have the recent case of the Vinod Dua case, in which the sedition charges was implied against Vinod Dua for criticizing the present government, that is the against Narendra Modi. His speech was there, so he was charged with sedition. But Supreme Court quashed the FIR because that did not resulted in violence, guys. So every time while solving the sedition passage, only word that you have to remember is that there should be a violence that has been resulted. Okay, next slide. Now let's understand some general knowledge. For the United Kingdom, the sedition law has been repealed. In United States, the sedition law is a federal law. It is used. And for Australia, Singapore, the sedition law has already been repealed. Now it's time for India. Let's have an eye on what the Supreme Court and the central government does in the next years to come. Definitely, it is not going to be done very soon. It will take at least 6 months or a year for the sedition law to either get repealed or be amended. But in United Kingdom, Australia, Singapore, the sedition law has been impeached. Now the way forward is that either the central government will be repealing the law completely. That is the first option the central government has. Second option is the central government will be bringing amendment to the sedition law. So whatever it is as of now, there will be some changes, like you will not be getting a government job, or you will not be having your passport, you cannot travel abroad. Such thing might be changed by a committee that the Home Ministry will be forming. Okay, either that the central government can do so on the basis of the national unity and integrity and freedom of speech and expression, reasonable restriction. If the central government does not repeal the law completely and makes amendment, definitely again it will be going back to the union government, and as we know that the Supreme Court will be again sitting on the matter on July. Okay, Supreme Court will be sitting in the second week of July again on this matter. So it will be taking the report what the central government is doing. If the central government does not repeal the law completely, definitely again it will be challenging the Supreme Court. And let's see what the Supreme Court will do then. We have to keep an eye on that also. But for Clat 2022, this is done. Sedition law is done. It will be just here because you are having only 30 days for Clat, and in that time the government is not going to take any action. Just hope for that, because if the government take any action, you will be having something more in your bucket to learn. Okay, so this is the sedition law in other country. Next slide, I hope. Yeah, so this is sedition law in other countries. You have to remember, guys, the whole sedition law, that what is sedition law, the present circumstances, it is kept in abeyance. So if you are getting a question in your legal passage that according to the present situation and you are getting a fact, you have to not use the sedition law. No FIR will be registered. If it is registered, the person will move to the court. The court will quash the FIR. The court will take into consideration the proceeding, and the central government is going to repeal the law, or it is going to amend the law. This is the present situation. That's all for guys from my side. If you have any doubt, you can let me know.